Good morning, everyone. Welcome to Background Check 101 presented by my HR Counsel and Yardstik. Thank you for joining us this morning. This morning we're going to talk more about background checks from a legal perspective, and then also learn more about what my HR Counsel and Yardstik can do for your company. I'm going to have a demo of Yardstik and how that would work with my HR Counsel. And we'll have time for any questions that you might have at the end as well. I'm Britt Waterman. I'm a senior attorney at my HR Counsel. Joining me today are Audrey Heidorn. She's the platform account executive at Yardstik. Eric Scheel is the vice president of product at Yardstik, and Terry Stark is the vice president of operations at Yardstik. And they are all here with me today. So let's get into background screening. Kind of the overview of where our discussion is going to take us today. We'll discuss what is background screening, why do employers perform background screenings, compliance requirements, best practices, and frequently asked questions. My HR Counsel's background screening services powered by Yardstik, and why make my HR Counsel and Yardstik? Why join up with my HR Counsel and Yardstik, who are partnering together? So what is background screening? Pre-employment screening is a service that employers use that is seeking job-related and legally obtainable information on job applicants, looking at public and private information about an applicant's qualifications, such as educational or employment references, also behavior, criminal record, drug screen, things like that. Employers are concerned about risk, understandably, want to know if an applicant is qualified for the position that they're applying for, and also if there are risk factors that would come with hiring a particular applicant that would need further consideration prior to hire. So what can you check with background screening? What does that involve? Background screening can check for a number of things. Like I said, criminal record, past employment, and educational achievement verification. You can obtain credit reports, driving records. If you have a position that involves use of a company car or driving, you might want to obtain those motor vehicle records, professional licensing, other public information. Sex offender registry would be an example of other public information that would be checked with a background screen. Civil records, disbarment or sanctions list, and then also social media searches, which is one that we get a lot of questions about. That's very relevant today. Pitfalls of background screening. So this is why you need to consult with counsel when it comes to background screening. So pitfalls, things that could be dangerous to your company when it comes to background screening: failure to follow state-specific laws. There's a whole web of laws that interconnect surrounding background screening. There are what are called ban-the-box laws. You may have heard of laws regarding when you can ask about criminal history information, whether you can put a box on your application asking, check here if you've got a criminal history. Fair chance laws, which are go a little bit beyond ban the box and require looking a little further into an applicant's criminal record if a criminal history comes back on a background screen. Some states have a prohibition on obtaining or considering credit history. Another pitfall of background screening would be failure to comply with the federal law, the Fair Credit Reporting Act, and we'll get into that in just a moment. A big issue is misuse of and failure to safeguard background information. A background check report contains personal identifiable information, such as social security number or date of birth, that type of information, sometimes driver's license number, information that is specifically identifies a person. that could, if disclosed, could put a person at risk for identity theft, for example. So that type of information needs to be kept confidential. It needs to be kept away from everyone except your hiring manager and human resources. There's a high risk of an invasion of privacy claim if that background report is not protected and not kept confidential apart from someone who has a business need to view that. Even the application for a background check has personal identifiable information and also protected class information. Usually an application for a background check will ask for the date of birth, specifically for checking a background screen, not for any other particular reason, but that does disclose protected class status. So those applications that are filled out to apply for the background screen should really be kept solely to your human resources department and should not be something that should be accessible by anyone else within your company. Why do employers screen? There are many reasons. Reducing workplace violence is a reason. If you can screen, that would be a reason to screen for criminal history. Avoid lawsuits for negligent hiring, retention, promotion, or supervision. Demonstrate due diligence in hiring. Prevent time wasted in recruiting and hiring the wrong person. Brand protection, ensuring that the employer has accurate information about past criminal conduct in order to make an informed decision in accordance with state and federal laws. Identify falsehoods or discrepancies about employment or education claims. Lower turnover rate by increasing quality of hires, and prevent the loss of customers and workplace disruption. Certainly it is more cost effective to sort through your candidates to weed out people who are not going to be a good fit with your organization at the beginning, rather than go through the work and the expense of training someone and onboarding and training and getting further into the employment and realize their education is not what they said it was, their employment background is not what they said it was, or something, God forbid, something happened, there's an incident of workplace violence, or you have an issue with theft or embezzlement and you haven't performed that background check. You could be subject to a lawsuit for negligent hiring if you if you had reason to know that someone had a propensity for violence and you didn't take action to keep that person out of the workplace. That's something that could create liability for you. That's why you would want to screen for background and take action based on that background check to screen your hires and to make sure that you're hiring individuals who are going to be appropriate employees and follow your code of conduct within your organization. Compliance requirements, like I said, there's federal law, there's state and local law. Some cities have made their own law, so it really is at 3 levels. Timing during the hiring process, as I said, with those ban the box laws, they vary as to when you can ask for criminal history information. Some states and cities, there's no federal law regulating when you can ask about an applicant's criminal history, whether they have been convicted of a crime, a felony, a misdemeanor, however you want to phrase the particular question about criminal history. There is no federal law prohibiting you from doing that at the beginning of the hiring process. However, some states and some cities have made laws regulating the timing of that. Some states and cities require you to wait until the applicant has been selected for an interview before you can request information about criminal history. Some states and cities request wait until a conditional offer has been made before you can request that information. So you have to pay attention to the timing during the hiring process when you are initiating that background screen process, when you're even bringing that into consideration. So there's compliance before, during, and after the background check process. Before, as I said, when can you introduce that? When can you ask a criminal history question? When can you ask someone to take a background check? During the background check process, we'll get into the Fair Credit Reporting Act and the process that needs to be followed to comply with that federal law. And after the background check, in some jurisdictions, what you have to do after you receive those reports and the process that you need to take. What do you do with background checks reports after you have them, after you've decided to hire or not to hire? What do you do with the reports in order to be compliant? These laws, there is no limit on employer size. Some federal laws and state laws apply to employers of a certain size. These background check laws that we are speaking about today apply to employers of any size. If you've got one or more employees, these laws will apply to you. And there are compliance requirements whether you are performing your own in-house background check or whether you are using a third-party CRA. So in-house background checks. In-house background checks would be conducting background checks without employing a third-party service to compile the information for you. These are ill-advised and could end up costing an employer far more than the cost of employing a legally backed background screening service. The risks of doing in-house background checks, you could inadvertently discover protected class information, which means you could see photos of an applicant. You could see an applicant's membership in an organization that has a racial or an ethnic or a religious affiliation. You could see the applicant's marital status. You could see something that reflects their sexual orientation. You could see a high school yearbook, which is going to disclose their age. All of this information is information that cannot be used or considered during the hiring process and is something that you don't want to inadvertently stumble across. And now you've opened the door, you have that information, you run the risk of facing a discrimination in hiring lawsuit if your applicant perceives that they were not hired because you have obtained this information and potentially considered this information in making your hiring decision. You have the risk of, in addition to protected class information, illegally considering off-duty conduct or protected activity. Protected activity would include what we know as protected activity, which would be like union activity, organizing, taking protected leave, requesting accommodation, things that occur within the workplace, but also California, Colorado, Louisiana, New York, North Dakota, all of these states prohibit employers from firing or retaliating against employees for off-duty lawful activity, including speech. And 30 states altogether have lawful off-duty conduct laws when you include tobacco and alcohol use in those laws, and including recreational marijuana use in Illinois. So what does this mean? If you see, if you're searching in-house, you're searching Facebook or Twitter, you see an employee on spring break smoking marijuana in Illinois, or you see them, with a political t-shirt and they're drinking a large alcoholic beverage, you may think, well, we don't want to hire that person. That doesn't look like the kind of person we want. That person's engaging in lawful off-duty conduct, and you can't consider that conduct if you are operating in one of these jurisdictions that has a lawful off-duty conduct state. So you've just discovered something that you can't consider, and this applicant, if you do make your hiring decision based on that lawful off-duty conduct, this applicant could have a claim against you. Public records can be incomplete, outdated, or inaccurate. If you're looking for your own records, if you're going to the courthouse or that type of search, It's not always the most accurate way of finding these records. Disclosure or misuse of results could result in an invasion of privacy, defamation, or violation of federal background check law claims. There is what's called an intrusion on seclusion claim. Employees and applicants have successfully sued employers for gathering non-work related personal information. If you're accumulating information about someone's personal life that is non-work related, and you've gathered this information, if you've done an extensive social media search and you've collected this personal information, the applicant could have an intrusion on seclusion claim against you for intruding in their personal life, gathering too much information about their personal life. Invasion of privacy claim would be if you were to publish private facts, meaning if you were to search public records or other records that you could access about an applicant, and then you were to disclose what you found to a third party or to someone else, you could be subject to an invasion of privacy claim. And even if you, in some states, doing an in-house background check, you may still need consent. This isn't something you could do behind the applicant's back without letting them know. For example, in Georgia, you can do a criminal record search using the Georgia Crime Information Center Council. You can get criminal history records with the employee's consent or with fingerprints. It is possible to get records of in-state felony pleas, convictions, and sentences with enough identifying information in cases, even if you have no consent. However, even if you're accessing these public records, this criminal record search you can do through the state that doesn't require a third-party service to access this information, you still have to inform the applicant of all of the information that you considered in making your hiring decision, the specific contents of the record that you considered, and the effect of the record on your decision. So if you, this is Georgia specifically, just used as an example, if you collect these criminal records that are publicly available in Georgia, and you make a hiring decision based on what you find about their criminal history, you have to inform that applicant, this is the specific criminal history information that we found, and this is the effect it had on our hiring decision. If you fail to provide that information to the applicant, that is a misdemeanor. Obtaining this information under false pretenses or communicating this information to anyone else except as permitted by law. Again, obtaining it under false pretenses would be, accessing when you need consent, not having the consent of the applicant, or communicating the information, again, disclosing it to a third party, publishing it to a third party without consent. That can result in fines up to $5,000 or imprisonment up to 2 years. And that's for misuse of information that is publicly searchable that you can go in without the help of a third party. Negligent disclosure, accidentally letting somebody, a third party who shouldn't be seeing that information, a fine up to $100, imprisonment up to 10 days. I mean, that's a risk you would run with doing in-house background checks. That's just one example of state law, and why you would want to leave background screening up to the professionals, because you don't want to end up in jail because you didn't follow requirements that you may not even know about. Some other examples, California doesn't let you ask about or consider certain marijuana related crimes, misdemeanors more than 2 years old, arrests or detentions that don't result in convictions. These are examples of things that California won't let you consider. If you go searching on your own, you might uncover these, and you can't get the toothpaste back in the tube, so to speak. Once you've discovered these things and you let this inadvertently influence your hiring decision, this applicant that you don't hire may have a claim against you if they believe that that information that you shouldn't have considered has influenced your hiring decision. So who do you turn to? Consumer reporting agencies. Who is a consumer reporting agency? A person or entity who regularly engages in the practice of assembling or evaluating consumer credit information for the purpose of furnishing consumer reports is a consumer reporting agency. And that consumer credit information includes all of the records that we talked about in the beginning. It is not just a credit report. Consumer reporting agencies get more than just a credit report. They are your agencies that will get you all of the records that we discussed in the beginning. CRAs are subject to regulation under the Fair Credit Reporting Act. Some requirements of an employer: if an employer is using a CRA, an employer must certify to the CRA that it will comply with disclosure requirements, that it will comply with adverse action requirements, and that it will never use the information provided to violate equal opportunity employment protection. So that's something that an employer must certify to the CRA, that they must promise to the CRA. CRAs are subject to their own regulations under the Fair Credit Reporting Act, and we'll get into that with the Fair Credit Reporting Act. What is a consumer report? As I said, it's not just a credit report. A consumer report is any written, oral, or other communication of any information by a CRA bearing on a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living, which is used or expected to be used or collected in whole or part for the purpose of serving as a factor in establishing the consumer's eligibility for a number of purposes, including employment purposes. So that encompasses a great deal of information that would be involved in a consumer report. So it's not just credit, it's not just criminal history, but anything about reputation, personal characteristics, mode of living. That would include social media searches and employment and educational verification, as we discussed. So the Fair Credit Reporting Act is the statute that governs CRAs and governs background checks when you're using a CRA. The Fair Credit Reporting Act promotes fair and accurate credit and other types of reporting done by CRAs. It does establish requirements for CRAs to adopt reasonable procedures that are fair and equitable. It imposes requirements on employers using CRAs regarding disclosure, consent, pre-adverse, and adverse action, and we'll get into those in just a moment, but those are requirements on employers under the FCRA. Sharing credit and consumer reports can actually make a person or entity a CRA, and thus subject to FCRA requirements for CRAs. Now, what do I mean by this? So a CRA is required under the FCRA. CRAs must maintain reasonable procedures to ensure the accuracy of their consumer reports, and that the consumer reports are provided only for permissible purposes and reasonably investigate consumers' disputes of reported information. So those are the rules for CRAs. That's what a CRA needs to do. And a CRA, as we said, is an agency that compiles all of this information for the purpose of a third party. Well, if you've taken a background screening report that you've received from a CRA and you communicate that to someone else, you've just become someone who is, you've just become an entity who has compiled information and disseminated it to a third party. You've just made yourself a CRA. And this may sound far-fetched. However, this is based on an actual case. A temporary staffing agency in Massachusetts was obtaining consumer reports from CRAs and passing them along to their client companies. So the temporary staffing agency was hiring employees, getting employees into their talent pool, and running consumer reports, background checks on the employees that they were placing in their talent pool. And then when a client company would say, you know, we need 10 employees for this project, and we want to see their background checks, the temporary agency would say, okay, here are 10 candidates and here are their background checks. An appeals court found that by passing on these consumer reports, the temporary agency was, quote, regularly engaging in the practice of assembling or evaluating consumer credit information for the purpose of furnishing consumer reports to third parties. So therefore, the staffing agency that was handing these background checks over to the client company became a CRA. They were required not just to comply with the employer requirements under the FCRA, but now they were required to comply with the CRA requirements under the FCRA. And like I said, those are ensuring the accuracy of the reports, reasonably investigating consumer disputes. If you're not set up to do those things, don't pass a consumer report along and don't make yourself a CRA. Presumably you're not set up to assume the responsibilities of a CRA. Don't inadvertently do the work of a CRA. Keep that consumer report that you get back within your organization. As I said, it should not go further than human resources and the hiring manager. It should not be something that gets communicated to third parties for any reason. So what are the requirements of the FCRA along the way for employers? So before conducting a background check with a CRA, an employer must inform the individual that they may be requesting a report. So what are the requirements for disclosure? The disclosure must be easy to read in plain language, so no legalese. A disclosure, you can definitely ask your CRA can provide you with disclosure. If your CRA does not provide you with a disclosure document, your legal counsel can certainly provide you with that. However, even if it comes from counsel, it's not going to be in lawyer language. It has to be in easy to read plain language. It must be separate from all other documents. So this is not something that can be a paragraph on a page containing other onboarding information. The disclosure has to be its own page. It must include a summary of your rights under the Fair Credit Reporting Act, and it should include a description of the reports to be obtained. The summary of your rights under the Fair Credit Reporting Act, again, your CRA should give you a copy of that document to give your employees with the disclosure. That's something, if you don't have that for some reason, it's publicly available. It can be obtained at consumerfinance.gov, or I mean, even if you Google summary of your rights under the Fair Credit Reporting Act, you should find the federal government website that has the PDF of that you can print out and give to an employee with disclosure. It's very easily accessible and very important that it is provided with your disclosure. A description of the reports to be obtained. There are two types of reports. There are consumer reports and investigative consumer reports. Consumer reports, any written, oral, or other communication of information by a CRA based bearing on your, as we discussed, credit standing, character, general reputation, may include credit reports, criminal records, driving records, anything like that. Investigative consumer reports, not as common. I certainly can't recall a time when I have seen someone particularly using investigative consumer reports. They include similar information, but they are obtained through personal interviews with individuals who are acquainted with the subject or who may have knowledge of relevant information. This can include employment references, so I have seen it in that respect, but as far as personal interviews about mode of living or general character, that is not usually something that individuals are or employers are obtaining. It's not as common. However, if you are going to be acquiring these investigative consumer reports, if you are going to have the CRA interview people who the applicant knows, you must have a description of that is something you are going to be obtaining. So what are the consequences of failing to provide this disclosure? This one-page, easy to read, plain language, separate document. McDonald's paid out a $950,000 settlement for running background checks on 2,500 employees without providing disclosure, and that was the entire basis of the settlement, was failing to provide this disclosure as a separate page in easy to read plain language with the summary of your rights. They didn't provide it as a separate document with the summary of your rights, and they paid out this large almost $1 million settlement for doing so. Authorization before conducting a background check with the CRA. First you disclose, then you obtain consent from the individual to conduct the report. Requirements for authorization: it must be a written authorization. Again, like the disclosure, it must be separate. It must be applicable only to the background checks. Sometimes onboarding will be done online. It will be a click-through agreement. Checking an I agree box to the terms and conditions of an employment application does not constitute valid authorization to conduct a background check. If you have this as part of your employment application, and your employment application states all employment is subject to passing a background check will be conducted, I agree with all of the terms of this employment application, that's not enough. That's not authorization. Authorization has to be something specifically authorizing the employer to conduct a background check very clearly. Consequences of a non-compliant authorization: Domino's Pizza paid out a $2.5 million settlement, and Publix, the grocery chain, paid out a $6.8 million settlement for non-compliant authorization. What was happening in those cases was the settlements were due to having applicants authorize a liability waiver on the same page as the background check authorization. So they were giving applicants a document where the applicant would check that they consent to the background check and they do not hold the employer liable in connection with the background check, and they should only authorize one thing on that page. Having them authorize and waive liability in the same sentence in the same document was not compliant. And again, this should not be a click-through where you have to click next to move forward in the onboarding process. Clicking next to move forward does not mean that the applicant consented. Pre-adverse action. So you get the consumer report back and you're thinking about making your employment decision. Before making your employment decision on the basis of the results of the background check, you must comply with the pre-adverse action requirements. You must notify the individual that a decision regarding the employment is pending. You must provide a copy of the consumer reports. You must provide that summary of your rights. Again, you must set a waiting period for the individual to dispute inaccurate information, and you must notify the individual that the CRA did not make the decision and the CRA cannot provide reasons for the decision. The waiting period, just to make a note here, when you set a waiting period, 5 days is generally considered a reasonable amount of time between the pre-adverse action and making the final hiring decision. What the waiting period is generally for is sometimes information on a consumer report, a background check, is wrong due to identity theft. For example, I've seen where someone's relative or acquaintance commonly gives that person's name and date of birth for police. If they have an extensive involvement in the criminal justice system and they're giving someone else's name and date of birth to the police, your applicant in that case may have a letter from the Bureau of Criminal Apprehension explaining that the criminal record that comes up is not their record. They may have other examples of identity theft that show that the information on the consumer report, whether it's credit information, criminal history, does not apply to them, that their identity has been misused and that resulted in that information. Unless you operate in a fair chance jurisdiction where you have a Fair Chance Act, you do not have to use this waiting period to allow for evidence of mitigation or rehabilitation, explanation of the criminal history. If you do allow it, if you allow it for one applicant, you must allow it for all applicants. If you're going to consider evidence of rehabilitation since the offense occurred, you've got to consider that then for all of your applicants. You cannot make a special exception in one case. You must be consistent. If you're going to consider that information, work with counsel to set up a policy that mirrors those that are used in fair chance jurisdictions to make sure you are being 100% consistent and not having a disparate impact. Adverse action, once you've made the decision, you've notified them of the pre-adverse action, you've passed the waiting period, you're going to go with your hiring decision. You have to notify the individual of the final decision, provide contact information for the CRA. There's that summary of rights again. Got to give them another copy. Again, notify them that the CRA did not make the decision and cannot provide a reason for the decision. You have to notify them of their right to request a free copy of the consumer report from the CRA within 60 days. And again, notify them of their right to contest the results with the CRA in case there is inaccurate information. Failure to follow the pre-adverse adverse action procedure can be costly. Uber paid a $7.5 million settlement for failing to follow the procedure. Lowe's $2.2 million settlement. Dish $1.75 million settlement. Swift Transportation paid out a $4.4 million settlement, and that was just for failing to advise applicants that they could access and contest the background check report. I mean, the one piece of the adverse action requirement was missing, and it cost them $4.4 million. So it's following these steps is very serious. Criminal background checks, state laws. There are a patchwork of state laws, like I said, regulating when and whether you can request this. States differ widely on what types of records can be sought: arrest, deferred adjudication, detention, how old the conviction can be. As marijuana laws are reformed, more prohibitions on the use of marijuana-related convictions may be coming. Fair Chance Act, just to give an overview of those, Fair Chance Acts require you, as part of the pre-adverse and adverse action process, to do a written individualized assessment of how the conviction relates to the position sought. You have to send your written assessment with the pre-adverse action notice. You do have to allow in those jurisdictions any evidence of mitigation, rehabilitation, explanation of what happened with the criminal offense. After you get that information back, you have to do another written individualized reassessment explaining how you considered that additional information and how you considered all factors of the criminal offense, how it relates to the position sought. And you have to send out that reassessment with your adverse action notice. So that just enhances the pre-adverse and adverse action process. Other state laws, you know, different states have different requirements for certain occupations: working with children, working with the elderly, taxi drivers, security system installers. Some require specific types of background checks for those types of occupations. Credit checks, federal and state laws. Federal law prohibits the use of bankruptcies in making employment decisions. So the FCRA is the main law governing credit checks. The use of bankruptcy information is prohibited. Some states and cities prohibit obtaining or using an employee's credit report in making an employment decision. So at least 10 states right now have mini FCRAs that mirror the FCRA, but are a state law instead of a federal law, that place further limitations on credit checks For example, Vermont has a mini FCRA that prohibits obtaining or using an employee's credit report. And that may seem alarming if you are a bank or a credit union, or you are hiring for a position that would have access to your financial accounts or sensitive financial information. In these states that have these particular laws regarding credit checks, there are exceptions. There are exceptions for financial institutions. In Vermont, there are exceptions for police, firefighters, EMT. There can be exceptions for payroll employees, where the employee will have a fiduciary relationship to the employer, enter into contracts. So it really, again, goes back to show that you really need to be working with counsel and working with a legally backed consumer report agency to make sure that you are complying with all of these state and federal laws in what you can access and how you can use that information for the particular positions that you are hiring for. Federal law generally prohibits CRAs from reporting civil judgments more than 7 years old. I know that applies to civil judgments. That is a civil lawsuit. That is when that is not a criminal judgment. That is a civil judgment when someone is sued for anything from, in small claims court, or someone is sued for non-payment of rent, or someone is sued for personal injury or anything like that. Any type of civil judgment more than 7 years old cannot be disclosed. So best practices and frequently asked questions. Be aware of your legal responsibilities before, during, and after the background check. Know the advantages of using a legally backed background check, and ask before you act and avoid costly mistakes. Like I said, leave it to the pros. Avoid the in-house background checks. Make sure you are complying with the FCRA with those 4 steps that you need. Know your responsibilities under state and local law. Develop a uniform process for compliance. Make sure you are doing the same thing every time, treating every applicant the same way, keeping your process consistent. Keep these consumer reports in a confidential file. Do not keep them in the personnel file. Keep them in a confidential file that only HR will have access to, and retain them for 5 years from the date the check is conducted, whether you hire the person or not. And when that 5-year period has passed, destroy them securely, shredding, burning, pulverizing, rendering electronic files unreadable and unable to be reconstructed. Like I said, what could go wrong? We've already talked about some of those large settlements. For the FCRA, damages are capped at $1,000 per violation, but I guarantee if they find one violation that you've done, it inevitably leads to the discovery of multiple violations. You don't want to have one found, because if you've messed up one time, the odds are good that you've been non-compliant. There's a pattern of non-compliance, and that's going to add up at $1,000 per violation. And like we said, the class action suits are having judgments in the millions. Frequently asked questions, and I'll try to get through this as quickly as possible because I know we're short on time here. Is it true we can't find out about crimes an applicant committed more than 7 years ago? This is going to depend on your state law. This is entirely state law dependent. There are some arrests. You cannot find out about arrests that happened more than 7 years ago. In some jurisdictions, felony convictions can go back as far back as they can. So in some jurisdictions, there's no limit. It really depends on state law. We're a staffing firm, and our clients demand to see background checks. Like I said, don't make yourself a CRA. If you're a staffing firm, don't hand those background checks out to anybody because you're going to make yourself a CRA, and then you're going to be in a world of trouble there. We've hired someone before we waited for the background check results to come back. Now we found out that they've been convicted of murder. What can we do? If you if your position requires completion of a successful background check for hire, please don't jump the gun in certain cases and make exceptions and hire people before those results come back. Be consistent, wait for the results to come back. If you have hired someone and the results do come back, you can terminate based on the background check results. However, even if you're terminating and it's not a hiring issue, you still have to follow those FCRA procedures. You still have to follow the pre-adverse adverse action, even though it's a termination and not a failure to hire. The position we're hiring for requires driving. Can we find out if our candidates have ever been arrested for DWI? That's going to depend on state law, whether or not you can consider arrests. Again, you can't find out about arrests more than 7 years old, but whether or not you can find out and use arrests at all is going to depend on your state. I'd like to pre-screen candidates and not move forward with those who have a record. Can I do that? Again, the timing of when you can ask about criminal history is going to depend on your state and your city. In some jurisdictions, you're going to have to wait until after you've made a conditional offer before you can ask anything about criminal information, before you can even ask the question or consider any information. So if you're pre-screening candidates as far as using consumer reports, background checks, and then not hiring those whose records are unacceptable to you, that's fine. Just know when you can do that based on your state or local law and follow the FCRA procedure. Do I have to background check all my candidates or just those who raise a red flag in the interview? If you're doing it for one, do it for all, or have a valid non-discriminatory business reason for differentiating. For example, if you only background check employees who have access to your financial information, that would be a category that would be non-discriminatory. However, don't pick and choose. If you are background checking one employee, you should be background checking all employees. You shouldn't be doing this based on somebody gave me, a bad feeling in the interview, or I heard a rumor about this person, I'm going to run a background check. You should have a consistent procedure for this.
All right.
And so, go ahead. I'm going to.
Oh, go ahead. Okay. Thank you, Britt. Thanks for all the great information. Hi, everybody. I'm Audrey Hydorn. I'm a platform account executive with the Yardstik, and I'm just going to spend a couple minutes here just giving you a background of Yardstik, who we are, and our, I lost, you can stay on those slides, Britt.
Oh.
I'm not going to present them. So while she's pulling those up, I will just kind of carry on here. Yardstik is a human security platform for platforms. So what does that mean to you? That actually means, for those of you on the call that are customers of myHRcounsel, you'll soon to be able to seamlessly integrate or seamlessly have access to background screens via the myHRcounsel portal. So you don't have to kind of go off to the internet and do searches, and you'll have access to that offering within the portal. So with trust and safety and compliance being at the core of our business, you can ensure that everything that Britt just discussed from a compliance perspective will be handled by us. And from a background perspective, our beginnings really came from actually the youth sports world. A world where coaches and officials should be actually carefully vetted, screened, certified in order to be trusted to be working with children on teams. And we all want safety for our children and ensuring that, those who'd be interacting with them would not put them in danger is of utmost importance. So the founder of Sports Engine, a leading company in youth sports technology and in screening and certification, got to thinking that this is by no means specific to sports, and saw that no one was really taking charge of creating a platform for all businesses to do this, and thus created an opportunity to build an industry agnostic screening and certification platform for all businesses to reduce risk in their hiring process and ensure the candidates fit exactly what they're looking for in an employee. So this is how Yardstik was born. We're continuing to evolve screening and certification platform so it can be used by many different industries. So it's a perfect fit for us to partner with myHRcounsel, who interacts with many different industries across the nation. So we are a consumer reporting agency. We're committed through safety through certifications with the FCRA and memberships with the Professional Background Screening Association. And then all of the FCRA requirements that Britt just discussed, such as disclosures, authorizations, pre-adverse and adverse action letters, are really built directly into our packages. So you don't need to worry about whether or not you're being compliant, and really can focus on hiring the best people for the job. So if you want to go to the next slide, Britt, I will quickly review the packages that are available today. Again, you know, we can continue to add to these packages, but right now, as it stands, there's kind of three main packages: the basic instant national, the standard criminal, and the premium criminal package. So the basic instant national criminal really takes credit data and finds the address of the candidate and locates that to search a national criminal database to find any felony or misdemeanor convictions and any pending records. It also has Office of Foreign Asset Control, National Sex Offender Registry, and adverse action management, as do all of our packages have adverse action management. These databases are updated monthly, so there is a risk that there could be some outdated information from the point in time that you're running the check. They are $10 a screen with no surcharges. I will note that they are FCRA compliant, so they can be used for hiring purposes, which is great. But do note that there's probably, you know, certain audiences you should take into consideration when using this type of package, such as someone that may not be in close contact with a lot of different human interactions during their day-to-day job. The next package is the standard criminal package. So this does an address and social security trace. It does it does do a national criminal search and for any felony and misdemeanor convictions. But the key difference with this one is it goes down to the county level with the current address of the applicant. And this is important because not all convictions are reported to the national databases. Most of them are actually reported to the county. So if you're just doing a national search, you could be missing something at the county level. And we want to make sure that you're hiring the best capable people to do so. It also includes the global watch list verification, as well as the National Sex Offender Registry. Again, this package or these databases are actually updated continuously, so the risk of a gap in time is much less, and you share the most recent and up-to-date information available to you. And the results are in 2 to 3 days. The price for this one is $25 a screen plus any state and county surcharges that may be applicable. And then the premium package, I'll do this really, really quick, is basically the same as standard, except it's the most comprehensive with a 7-year county check. So anywhere you've lived in the last 7 years, or the applicant has lived in the last 7 years, we'll check at the county level. So it's really getting the most comprehensive and best brand protection for your company, and gives you the confidence that you're hiring the right people. And that's at a $40 screen plus the surcharges. And then if you go to the next slide, Britt, we have 3 additional add-ons to add to the premium package. And this was mentioned earlier, but motor vehicle record you can add to the package for anyone that's doing any job driving on the job, employment verification to verify their dates of employment, the title, and the last position held, and finally credit checks where applicable if someone's working with, if it has fiduciary responsibilities, or it's a franchise owner that wants to own a franchise, you can use the credit checks add credit check to your premium package as well. So with that, I know we've got 5 minutes left. I wanted to hand it off to Eric and kind of go through the demos. Actually, Britt, don't click to the next slide. He'll go through the demo personas quickly, and then we'll take a look at what the user experience looks like using Yardstik.
Perfect, thank you, Audrey. So what we're going to demo today is I'm going to log in as a client into the Yardstik application. The client is Universal Services, and we're going to run 2 screens, one on Joe Clean and one on Hank Mess. You might be able to predict how it's going to go with each of them, but we'll see how the screens turn out. So go ahead, Britt, if you want to give me control, I'll just quickly log in and show the application. All right, so when you sign up for Yardstik, you will receive a login through myHRcounsel, and that initial login will allow you to come in and see your dashboard. And the dashboard for the Yardstik app is very straightforward, so you can see your applicants moving through the process. I can see I've got a couple of test records in here with Joe and Hank that I've done earlier today. And then the invite process, which really kicks all of this off when you reach that point that you want to do the screen, is you click quick invite, and the packages that Audrey just outlined are here. So we'll do a premium package. The standard permissible purpose, the reason for the screen is employment. There are other types of configurations we may have with different clients. And then I'll go ahead and do Joe Clean, and this is all just sample data in a test system here. So, and I'll send out my invite. So what that's going to do is send an email to Joe. You can see that it's been sent. You'll notice here the statuses are tracking if Joe clicks on the email, if the screening's been completed, whether it was clear, or whether there's some data that we need to consider on the report. And this again is managed all by our application and kind of walks you through that step process. One other thing that I want to note is that you do get to set your own branding so that your applicants will see a little bit of your company information because they know that they're going through this process for your company, in this case, Universal Services. So I can see I've got our little Universal Services logo here. So switching roles a little bit over to the applicant, this is what Joe Clean is going to see. So Joe is in his Gmail account and he's received this email that Universal Services would like to do a screen, and it's powered by Yardstik. So we are the agency here, so we have to have our information and contact on there. And then collecting that personal identifiable information, that's really the step that we take responsibility for here. So based on the screening package, we have specific data that we collect. Based on the location, we have specific disclosures, summary of rights, and so forth. And they have to agree to all of these as well as do an electronic signature. This is also where they can request a copy of their report be sent to them automatically. So I'll save us the time of clicking through all of that. In the meantime, we can go over here and look at our candidates, and I can filter down. Our application obviously has all kinds of filters and sorting here, and I can actually see the reports that have come back. So Joe Clean came back as clear. So what that means is that there was really no records found that would be flagged. We can see the date and the time on that. And then I can view the full report that came back for Joe Clean. It's a standard background screen report here. I could see the information for Joe throughout. If we go over and look at Hank, however, going back to our candidates here, we have a consider, and this is where adverse action comes into play. So you'll see we have two additional buttons here. I can proceed with Hank, or I can initiate the pre-adverse action. I could go ahead and pull up Hank's report. I have a copy of it open already from a test I did earlier, and I can see there's a number of felony convictions here for Hank. So unfortunately, we're not going to be able to move forward, and this is where I'll kick off the pre-adverse action. I can note some information on this and go ahead and hit send, and that will kick off that entire workflow that Britt covered in terms of notification. Hank will have an opportunity, if there's something inaccurate on his report, to work with us to clarify that and kind of take them through that process. So that's as quick as I can do the demo, but you can see it's pretty straightforward and easy process to send out the invite and track them through the workflow. So Britt, I will hand it back to you. And you should have it now.
All right. I know we're at time, and I just wanted to give you four, kind of takeaways in terms of why, after all of that great information that Britt provided in terms of being compliant as you're running background screens, why would you do that with why Yardstik and myHRcounsel is really around, safety and compliance. That is our number one priority. We're committed to safety and excellence in that field with our certifications in FCRA and membership with PBSA. And, again, you don't have to worry about the specific FCRA requirements using our services. You can focus on hiring the right people, and we'll focus on the compliance side of the house with all of the disclosures, authorizations, and pre-adverse and adverse action processes. Next slide. And the last two items are really just around, the user experience, saving you time and increasing the conversion and timeliness of your background screening. So, having an integration with the myHRcounsel portal really gives you the advantage of having it right there in where you're working today with your legal counsel. And you also saw the user-friendly dashboards to see statuses of the screens and where things are at. And then also just overall reduces risk and costs with the 24/7 access to legal experts that you have with your subscription to myHRcounsel, and kind of embedding that with your screening services that you would be interacting with Yardstik. So again, just trying to make it very easy for you, making sure you're compliant and making sure that you're hiring the best people for the job. And finally, if you're looking for more information, you'll have this in your follow-up email, but you can go to myhrcounsel.com/Yardstik to get more information and fill out a form, and we can be in contact with you about some offerings. Thank you. And Daniel, we can use this as part of the follow-up too.
Yeah, we will be sending a follow-up email, so we can send the frequently asked questions and the link to on the previous slide in that follow-up email. And if you have questions about compliance, you can always send questions to info@myhrcounsel.com. If you are one of our clients, you can always open up a ticket in the portal as well. But remember, compliance is not optional. That's why myHRcounsel and Yardstik are here to take the worries out of compliance for you so that you can focus on conducting business. So thank you all for being here today. Like I said, any questions, we'll be sending out that email with the link or info@myhrcounsel.com. Thanks for participating and enjoy the rest of your day.